Young Thug lawyer confronts judge about meeting. After a break, Brian Steele, the attorney for Young Thug, real name Jeffrey Williams, confronted Judge Glanville about the ex-parte meeting. Steele said he heard that Copeland confessed to killing Donovan Thomas and that Copeland was threatened with 2 years of jail time for refusing to testify.
So they wanted YSL so bad, allegedly, that they were willing to let Copeland go. And Copeland allegedly admitted to unaliving Donovan Thomas. So why would they make such a deal? No wonder YSL attorney was so upset, because everything that they were discussing in that meeting, he should have been there to hear the discussion, because remember, his client's life is on the line. If YSL is found guilty, then you're talking a lot of years in jail, if not life. And so there was concern and still is concern why this ex parte meeting took place without all the attorneys being present.
When Steele refused to disclose who told him about the meeting, he was also held in contempt of court and ordered to spend 10 weekends in jail. Ultimately, Steele was allowed to remain in the courtroom with his client, and the Georgia Supreme Court issued a stay on the jail order while Steele files an appeal. Steele and other defense attorneys then filed motions seeking Judge Glanville's removal, which he denied. Dement, Yatgadi, Kendricks, also on trial with Williams, then attempted to bypass the lower court and filed a motion with the Georgia Supreme Court. According to Kendricks' motion, Deputy District Attorney Simone Hilton allegedly told Copeland she would not prosecute him if he lied on the stand, and Judge Glanville coerced Copeland to testify. However, the Supreme Court sent it back, stating that a lower court judge would have to review the motion for removal. Judge Glanville then announced that the trial would be put on hold until the Kendricks motion and the motions filed previously could be heard. He made the announcement on the day he had planned a private review of the ex-parte meeting with the lawyers. Judge Glanville also announced he would release the full transcript of the ex-parte meeting, defending the meeting as proper based on case law. The court is of the opinion, based on the case law, that this was a proper ex-parte meeting, Glanville said. At that point, prosecutor Simone Hilton told Copeland that she understood some of his concerns were about potential criminal liability, which is why he has immunity, both federal and state. She then said, literally, Judge, you might want to close your ears. If you confess to a murder on the stand, if we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution for what you say in court. Copeland also asked if murder has a statute of limitations. Hilton replied, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. Hilton repeatedly told Copeland that the state does not want him in jail and wants him to be able to purge himself of the contempt charge by testifying. Hilton also told Copeland that whatever his truth is, that's his truth, and they know what he's said before but don't know what he will say on the stand. However, pleading the fifth again will keep him in custody. What the transcript says. The transcript indicates that the meeting started, without Copeland present, with a discussion about Copeland's representation. It appears that Copeland's lawyer Jonathan Melnick wanted to be discharged if Copeland agreed to testify, and lawyer Kayla Bumpus didn't feel prepared to step in. There was also a discussion about an email that Melnick sent to lead prosecutor, Fulton County Chief Deputy District Attorney Adrian Love, saying that the state was going to get Copeland killed, to which Love insisted they were not. After Copeland was brought into the meeting, he immediately said that he had never been truthful a day in his life and didn't comprehend what was going on. It appears that Copeland continued to argue with the prosecutors for several minutes about whether he agreed to testify or if he told them before June 7 that he planned to plead the fifth. Copeland also said that he never asked for immunity, but Hilton replied that he didn't have to ask for it. Now that it was given to him, he had to choose, and if he chose not to testify, he would stay in custody until the trial is over.
Listen, I'm not a lawyer, but this sounds like coercion to me. This sounds like some arm bending, muscle twisting. It sounds as though they backed him into a corner that he had no choice than to agree to testify. And when he did go on the witness stand, he showed how reluctant he was because he became a hostile witness. He didn't want to testify at all. And I guess he has some outstanding charges. I don't know his situation, what case is open on him. But that's why he agreed to testify, so his case can be closed and the charges get dropped. so he wouldn't have to do any jail time. But when he became a hostile witness and didn't want to answer the questions or plead the fifth, he was put in jail for a day. And so it just sounded to me as if they really backed him into a corner and pretty much let him know, if you don't testify, you're going to sit in jail. And if you do testify, you get immunity. And he said, I didn't ask for immunities. They said, well, it comes with the territory. You get it for agreeing to testify. But remember, he did not agree to testify until they strong-armed him. According to Copeland, he told them that he was going to plead the fifth. So it really sounded like coercion. And YSL attorney Brian Steele is saying, listen, we were not privy to this meeting, this ex-parte meeting that you all had. My client is on trial, so as his attorney, I should have been in on this meeting. And that's what this is all about. That's why they want this Judge Glanville removed, because he seems to be playing on one side. He's supposed to be impartial.
And when we say the trial is over, every last defendant has been tried. Not just these 6, the other ones too, Hilton said.
So then Copeland was threatened that he would be sitting in jail until everybody gets tried. And that could be the next 2 years.
Judge Glanville then attempted to ensure Copeland understood what was happening, but Copeland continued to say he didn't know what was going on and didn't trust anyone.
Of course he understood what was going on, but he just felt so threatened. If he agreed to testify, his life would be in danger, not to mention his family. Because remember, him sitting in jail, anybody can get to him, and his life really would have been in danger, and I dare say it still is in danger, because of that secret meeting that Judge Glanville had with the prosecuting attorney along with Copeland. And so they did put his life at risk. Now, in the meeting, Copeland had representation because although his attorney was away, the attorney did send a stand-in. But it does not compute the same way when your own attorney is not there, who fully knows all the details of that case. So it is not the same to send a stand-in who probably barely knows the case in its entirety.
Copeland then asked how many other defendants were left, and Hilton replied 12. At that point, Copeland asked to speak to his attorney Bumpus for a few minutes, and everyone left. When they returned, Copeland asked if he would be locked up if he lied. Hilton explained that if he said something different from what he had said before, she would ask him about it. When Copeland said that he had told different stories at different times and didn't remember what he had said, Hilton told him it was okay to say, I don't recall. The transcript indicates that Copeland was still concerned he would be locked up again and continued to argue with the prosecutors about what would happen if he lied on the stand or refused to answer questions. Judge Glanville once again attempted to explain to Copeland that he had been given immunity and could only be sent to jail if he refused to testify or committed perjury. The meaning of perjury was also explained to Copeland. Hilton continued to tell Copeland that as long as he testified, he wouldn't be locked up.
This sounded like a little arm twisting, a little coercion going on.
At one point, she told Copeland that if he just answered the questions, he could go home and be with his baby for her birthday, see his dogs deliver their babies, and talk to his nephews. After a few more minutes of back and forth between Copeland and the prosecutors, with Bumpus occasionally asking questions on behalf of Copeland, Copeland finally agreed to testify after another brief private conversation with Bumpus. Before going into the courtroom, there was a brief discussion about finding Copeland something to wear besides his jail clothes, but he insisted on wearing them to court so that people could see what the state did to him. Despite Steele's claim that Copeland admitted to killing Donovan Thomas during the ex-parte meeting, there is no direct mention of Thomas in the transcript. Copeland did say at one point, I did these crimes. I'm telling you that. However, when Bumpus asked him if he wanted to say something on the stand, Copeland didn't respond. During Steele's opening statement in November, he said that Copeland had asked Williams, Young Thug, to rent the car used in the murder of Donovan Thomas. Copeland allegedly told Williams he needed it to get his family out of harm's way, and Williams reportedly rented cars for friends in need. Copeland was never indicted in connection to Thomas. Shannon Stillwell and Demond Kendrick, who who are on trial with Williams, along with other defendants not yet on trial, have been charged with his murder. At this time, it is unknown when a hearing will be held on the motions related to Judge Glanville. The trial, which has been plagued by various disruptions, began on November 27, 2023, following the longest jury selection in state history. The defense has repeatedly raised concerns that the trial could extend for years due to the number of witnesses the state plans to call. Several other defendants have yet to go to trial. Some of these defendants were in court last week to indicate whether they intended to accept plea deals offered by the state. 5 defendants turned down the deals. 3 defendants have not made decisions yet because their lawyers were either not present or new to the case. Williams and 27 other suspected gang members were arrested on May 9, 2022, after a 56-count indictment was handed up. Prosecutors are attempting to prove that YSL, or Young Slime Life, is a criminal street gang responsible for numerous offenses and that Williams was the leader of that gang. Young Slime Life judge releases transcript of secret meeting with prosecutors, witness. The judge presiding over Young Thug's lengthy gang and racketeering trial on Monday released the transcript of a secret meeting he held in chambers last month with Fulton County prosecutors and a key state's witness. Prosecutors told witness Kenneth Copeland in the June 10 meeting that if he refused to testify, he could be jailed until defendants all have their cases adjudicated, a process that could take years. Outraged defense attorneys said they were excluded from the meeting and accused Chief Judge Earl Glanville of colluding with prosecutors to coerce the witness. When confronted about the meeting, Glanville held Young Thug's attorney Brian Steele in contempt for refusing to disclose how he learned about it. 2 of those attorneys sought Glanville's recusal, and the judge announced Monday that all proceedings are halted until another judge determines whether he should remain on the case. Glanville said the Fulton County District Attorney's Office requested the meeting, held in his chambers, but did not give him a subject matter. The judge's court reporter was present according to the transcript created. Prosecutor Adrian Love raised concerns about Copeland's understanding of an immunity agreement entered in exchange for his testimony. Copeland on June 7 was held in contempt and jailed for refusing to answer prosecutors' questions. At the time, Copeland said he would invoke his Fifth Amendment right against self-incrimination. After a weekend behind bars, he did testify. Love explained in the meeting that she had received an email from Copeland's attorney, John Melnick, accusing prosecutors of endangering Copeland by forcing him to testify. "You are going to get him killed. You have made him. You are making him a target," Melnick wrote, according to Love in the transcript. FU. Melnick was out of town during the meeting, and had sent another attorney, Kayla Bumpus, to represent Copeland. Bumpus asked how long Copeland could be held in custody for if he refused to testify. Both Love and Glanville told her it could be a long time.
So, attorney Kayla Bumpus had an interview with TSR Investigates. She's the attorney who stepped in to represent Copeland while his lawyer was away. He was out of town. And this is what she had to say during that interview with TSR Investigates.
Could be in there a while, let's put it that way, Glanville told Bumpus, according to the transcript. The judge said Copeland could return home that evening by agreeing to testify. He has the keys to his own freedom, Glanville told the attorney, according to the transcript. Bumpus told them there was a chance that Melnick would no longer represent Copeland if he agreed to testify. Love and Glanville told Bumpus that she might have to stay until Copeland's testimony was over, which they acknowledged wasn't fair to her because she was just standing in for the other attorney. Ultimately, it seems as if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings, and that is a problem because that has nothing to do with the best interest of Kenneth Copeland, and that has nothing to do with Kenneth Copeland's exposure, if he testifies, Love said. Bumpus clarified that Copeland might be worried about testifying for other reasons, including his personal safety. "We ain't gonna kill him. We're not going to kill Kenneth Copeland," Love said, in response to the concerns raised about his safety. Glanville said that Copeland getting hurt could be a collateral second and third order effect, according to the transcript. "Let's pray it doesn't happen, but first he has to give testimony," the judge said. Nearly an hour into the meeting, Copeland was brought into chambers and Glanville told him they wanted to give him the chance to ask questions and clear up any confusion before he was brought out to testify. Copeland told the judge he had never been truthful a day in his life, and said he didn't understand everything that was happening. Ada Simone Hilton told Copeland that he was immune from any prosecution based on his testimony, according to the transcript. She also said that if Copeland feared for his safety, there were things the state could do to protect him. But she said prosecutors did not want him behind bars during his testimony. But she said if he continued to plead the Fifth, he could remain in jail until the case was over. Glanville told Copeland he would have been allowed to plead the fifth had the state not offered him immunity. What the state decided is they said your testimony is worth more to them at this point in time and they really want to know what you have to say, Glanville said. The meeting ended with a discussion about Copeland's wardrobe. At the time, he was wearing a jail-issued jumpsuit, which Copeland said he wanted to wear in front of the jury. Y'all don't want to show the people how you all did me, he asked. I prefer to go in like this. He testified that day wearing his jail clothes. The Atlanta Journal-Constitution.
But today we are learning what happened in a meeting involving a key witness. Judge Earl Glanville released the transcript of a meeting he held last month that included Kenneth Copeland, also known as rapper Lil Woody. On June 7th, he was arrested and held in contempt after refusing to testify on the stand as part of an immunity agreement. A few days later, in the judge's chambers, prosecutors shared an angry email sent to them by Copeland's attorney, accusing them of making him a target by forcing him to testify. They said his attorney was threatening to pull out of the case. Prosecutors later told Copeland that if he still refused to take the stand, he could be in jail until every defendant had their case decided. He did eventually testify. Copeland had an attorney present for the meeting. She was a stand-in for his usual attorney who was out of town. Young Thug's attorney, Brian Steele, said other members of the defense were wrongfully excluded from the meeting. They're now trying to get the judge removed from the case.
So Attorney Bumpus said she did not tell Attorney Steele initially that there was a secret meeting. However, when he approached her about it, because he had heard about it, she came clean and she told him exactly what occurred in the meeting.
Kayla Bumpus says she did not tell Young Thug's lawyer about the meeting, but admits to giving additional information when he pressed about it. The problem with the meeting is not what was discussed. It's that Mr. Copeland was already a sworn witness. So defense counsel should have at least known about the meeting, Bumpus told Justin Carter. I did not tell Attorney Steele. I do not know who told Attorney Steele, but once they told him, he came and questioned me and I then did give him a rundown of what happened in the meeting, Kayla added. The witness had attempted to invoke his Fifth Amendment right on the stand when asked his age. Carter also explains how Lil Woody claimed to refuse immunity and be a state witness.
Here is TSR reporter reporting on the case, interviewing attorney Kayla Bumpus.
The YSL trial with Young Thug at the center just took a turn that no one expected.
It's like something I've never seen.
The judge just put the whole thing on pause, all because of a meeting that Young Thug's lawyer, Brian Steele, says was not right, improper.
Did somebody tell you? I'm not. You should have told me. You don't get to extort the court. That's what you're attempting to do at this point in time.
Did you tell Attorney Steele about this meeting?
No.
This woman was in that meeting, Lil Woody's attorney. We got the receipts, the transcripts, and she's telling the Shade Room what happened and how it could have just set this case on fire.
It just kind of all happened so fast.
I'm Justin Carter. This is TSR Investigates. Started with a viral moment. Rapper Lil Woody, whose real name is Kenneth Copeland, a star witness in this YSL trial, pleading the fifth during testimony.
Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
It went viral, and soon after, a meeting was called with the presiding judge present, Earl Glanville, to lay out Lil Woody's options moving forward. Prosecutors said that Lil Woody must either testify, not plead the fifth, or he'd be thrown in jail in contempt of court, something they supposedly agreed upon. But defense attorneys say this whole meeting was a tactic to pressure Lil Woody into testifying, something that he did not want to do.
Kind of walked in and I don't know who called the meeting or how that actually set up. It just kind of all happened so fast.
Attorney Kayla Bumpus just found herself in the center of the YSL trial because on June 10th, all she was doing was filling in for a colleague representing Lil Woody. She had no idea, though, that what was about to happen next may light the case on fire.
I got there, and then before I knew it, we were all in a room talking.
Something known as an ex-parte meeting, which by definition is a motion, hearing, or order granted on the request of and for the benefit of one party only. In this case, it was presiding Fulton County Judge Earl Glanville, two prosecutors, the court reporter, and attorney Bumpus. They were all there. According to these court transcripts, the majority of the meeting was prosecutor Simone Hilton in a back and forth verbal exchange with Lil Woody, trying to get him to understand that because he was granted immunity in this trial, he could not invoke his Fifth Amendment rights. And if he did, he would go to jail for contempt. They warned him that he could be there until the end of this entire trial if he didn't want to testify anymore. Quote, "The way that you purge yourself is to testify. That is what the state wants you to do. We don't want you in custody. I can't say that any other different way. We don't want you in custody. The only thing that's holding you."
So Lil Woody's concern in not testifying, when they were trying to coerce him into testifying, his concern was if they discover anything in his testimony that will incriminate him, will he be put up on charges? The state guaranteed him that no, you will not be put up on charges, but he was scared. He didn't believe them, and so he really didn't want to testify because he didn't know the law. And when you don't know the law, you're kind of leery of lawmakers making promises, because a lot of people have ended up in jail when they don't know what's going on. Although he had an attorney there present, she was a fill-in. She was not his usual attorney to advise him properly, I guess. So I wanted to know the limits on immunity, and so I looked on the webpage Justia, and this is their explanation.
Limits on immunity. Typically, a prosecutor offers immunity to someone who has committed a minor crime because they believe that it will help them catch or convict someone who has committed a major crime. Often, it arises in the context of organized crime, when the prosecution offers a subordinate immunity in exchange for testifying against the leader of the enterprise. If you agree to this type of deal, you must testify as promised, or you may face jail time and fines.
So there are limits to immunity, and this is why Copeland was so reluctant in testifying, because he knew that he would be caught in that snare sooner or later.
An individual who refuses to testify after being awarded immunity can be held in contempt of court and possibly jailed. Sometimes a prosecutor will bring charges against a witness who has been granted immunity.
And that's exactly what happened to Copeland. He had immunity, he pleaded fifth, and so he was put in jail for contempt of court.
The defendant can raise the defense of immunity by producing evidence to show that they received immunity with regard to the subject matter of the charges. The prosecution then must explain how they acquired all of their evidence. A blanket statement that they did not use the immunized testimony or evidence arising from it will not go far enough. Any evidence that the prosecution acquired from the immunized testimony likely will be excluded from consideration at trial. If excluding this evidence means that the prosecution has no case, the court will dismiss the charges. Waiving immunity. In rare cases, a former witness can waive immunity after receiving it. This allows the prosecution to bring charges against them based on their testimony. The waiver can be explicit, which means that the witness signs a written waiver. Or the waiver can be implicit, which may happen when a witness makes a voluntary statement to law enforcement without claiming immunity.
So it sounds as if Copeland had implicit immunity because he made certain statements and the state gave him immunity, although he didn't ask for it, because they were desperately trying to get him to testify against YSL.
An individual sometimes will implicitly waive immunity in advance by choosing to testify rather than asserting their Fifth Amendment privilege.
So you guys see how complicated this gets. And this is why Copeland kept saying, I don't understand. I don't understand. I don't want to testify. So it gets complicated. If you get immunity and you waive your immunity and they know that you have charges on you, they can double back and file charges and get you put in jail. At least press charges on you. because they already got the goods on you. It's very, very catch-22, isn't it?
Quote, the way that you purge yourself is to testify. That is what the state wants you to do. We don't want you in custody. I can't say that any other different way. We don't want you in custody. The only thing that's holding you is refusing to testify, end quote. Lil Woody, though, firing back repeatedly, saying that he never wanted immunity in the first place. And in turn, he felt like it was a trick to get him to testify and not plead the fifth. Quote, I don't trust, I don't know what's going on, I don't trust nobody.
The problem with the meeting is not what was discussed. It is the fact that Mr. Copeland was already a sworn-in witness. So the meeting, the defense counsel should at least have known about the meeting.
And that's
So that was Attorney Bumpus saying that she was in the meeting and there wasn't a problem with the meeting. However, there was a problem that YSL attorney was not invited. He wasn't invited to the party, y'all. And he should have been there to represent his client.
when it all hit the fan. Young Thug's attorney, Brian Steele, caught wind about this meeting and took it straight to Judge Glanville.
I'm going to put you in contempt because that is not attorney-client privilege. Attorney work product privilege. I am not. How did you get that information supposedly from my chambers? Did somebody tell you? I'm not. You should have told me.
It got ugly. Judge Glanville held Steele in contempt of court for refusing to tell the judge how he found out about the out-of-court meeting. He was ordered to serve 10 consecutive weekends in jail. Did you tell Attorney Steele about this meeting?
No, I did not tell Attorney Steele. I don't know who told Attorney Steele. But once they told him, he came and questioned me. And I did then give him a rundown of what happened in the meeting. So there were things he knew already and there were things he didn't know. The problem is I was never told that the meeting was confidential. There was never an order to say that I could not discuss the meeting. I guess he's kind of just mad that it got out.
Why would he be mad that it got out? If this was
because
not
it was improper. Defense believes that there was some material or some conversations that took place that they should have been made aware of. And so they're objecting to the validity of this ex-parte meeting.
And you do nothing, I'm shocked. I'm appalled at you. I sit here, that is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation.
And they may get their wish.
Motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7.
Judge Glanville ordered Monday that motions filed to have him recused from the case be sent to another judge before the case continues. The judge says that there is no timeline and the trial will not continue until a decision is made on his recusal. It has defense attorneys across the board wondering, what's next? Here's what Bruce Harvey told the ABC affiliate in Atlanta, WSB-TV.
If Judge Glanville is recused, then what happens? And what happens to the entirety of the case?
It's like something I've never seen.
Judge Glanville assured the courts on Monday that there was no wrongdoing here and he stands by his actions. But as of now, Young Thug, he's going to have to thug it out a little bit longer in the Fulton County Jail after yet another delay in what's now known as the longest criminal trial in Georgia history. Of course, we'll be following this.
Here is a little clip of Attorney Brian Steele getting very tempered with Attorney Love and voicing his opinion to Judge Glanville.
If I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation, just machine. I gave the state everything. There's been no there's been no purposeful. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8. After 8 last night, I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time. Okay. And I apologize that I'm getting temper. But I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, can we strike the
No, I'm speaking.
Can we strike
Hey, everybody, calm down. Everybody, both of you, please be seated.
Judge, I'm not
Both
done.
of you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the case.
Mr. Steele.
I asked you, please.
Mr. Steele.
How would you feel if you were being treated
Mr.
like
Steele.
this? I'd like to finish.
Mr. Steele.
That is it.
So now everyone is waiting for the fate of Judge Glanville. Will he continue on the case, or will he be given the boot and another judge take over? And will the case be dismissed, or will there be a continuance? Oh, so many questions. Anyway, guys, on that note, I'm over and out. I'm going to catch you guys on the next one. Thank you for watching.